Good afternoon from my 400 square foot apartment in New York City. My name is Alexandra McGarris, a partner in Venable's New York office and part of our advertising and marketing law group. I am joined today by my colleague, Deborah Bessner, also part of the ad law group and the New York office of Venable. Couple of housekeeping notes. For those of you listening in that are barred in New York or California, this session has been approved for CLE Credit. At the end of the program, we will distribute a code via the Q&A chat section on your screen that you can use to submit for credit. We will be taking questions via the Q&A chat section. However, I expect we won't have time to answer them during the program, but instead we'll get back to you on a one-on-one basis. Also, our contact information is included in the slideshow. Feel free to email us after the program if you have questions that you think of later on. We want to thank you for joining us this afternoon in these very strange and uncertain times. On behalf of me, Deborah, and all of Venable, we hope you and your families are safe and healthy and taking care. Today's webinar is all about using and managing customer reviews compliantly. When it comes to searching for a restaurant, booking a hotel, or shopping for a product online, consumers rely on reviews in making purchasing decisions. Over the last several years, numerous studies and surveys have confirmed the importance of online reviews. A highly cited study estimated that a one-star rating increase on Yelp translated to an increase of 5 to 9% in revenues for a restaurant. Another study found that a 1-point boost in a hotel's online ratings at sites like Travelocity and TripAdvisor is tied to an 11% jump in room rates on average. There is also a growing body of research suggesting that early positive signals can create a herd effect, leading to even more consumers to purchase a product. A fake review from a seller is false advertising. Marketers may use fake reviews to influence algorithms and recommendation engines that can determine whether or not the consumer ever sees a product or service listing. Fake reviews pollute our markets and distort fair competition, especially online. Section 5 of the FTC Act prohibits deceptive practices and unfair methods of competition. Serious violations can even be prosecuted as misdemeanors. I just quoted from a dissenting opinion recently issued by FTC Commissioner Rohit Chopra in an October 2019 FTC case involving a cosmetics company that was using and actually requesting employees to submit fake reviews on Sephora's website. I highlight that quote from Commissioner Chopra because it really emphasizes the importance the FTC as an enforcement agency, as a regulating agency, has placed on customer reviews, because from its perspective, a marketplace only functions if consumers can trust the information available. And as Commissioner Chopra said very eloquently, fake reviews or misleading reviews pollute the marketplace and don't permit consumers from making rational purchase decisions. And that's what these laws and regulations that we're going to discuss today are all about with respect to customer reviews. When we talk about reviews, we're very broadly including, submissions that are made by customers or users of a product or service on review sites. So think of the BBB or Yelp, Trustpilot. Also directly on e-commerce sites such as Amazon and Sephora that sell multiple advertisers or merchants' products, but also companies' own e-commerce sites, but also includes things like likes on social media platforms, LinkedIn, YouTube, subscriptions, etc. Those are also considered reviews. When we think about the ways that reviews and advertising law intersect, I generally think of it in three buckets, and our presentation will more or less follow this roadmap. First, when you think about incentivized reviews are considered endorsements and therefore need to comply with the endorsement guidelines. So if you are asking or a customer or consumer to submit a review in exchange for really anything of value, entry into a sweepstakes, a discount on a future order, or even a donation to a charity, that will be considered a paid endorsement and need to follow with those rules. Second, reviews oftentimes can contain claims about your product or service. That's typically the entire point of a review, is a customer is providing his or her feedback on either quality or performance. Performance claims can be made, and you need to be careful that the claims that are made in reviews are indeed substantiated, and we'll talk about the control or knowledge an advertiser has on reviews that can contain claims. And then finally, when we talk about managing reviews, either on your own website, third-party sites, and the internet at large, whether or not the presentation, the display of the reviews, and its kind of management that you are doing to ensure that the reviews are accurate, whether or not it provides some sort of implicit claim that the reviews out there provide a full and accurate picture. And we'll talk about ways both advertisers can compliantly manage negative reviews to the extent that they are either inaccurate or reflect improper or illegal content. So when we talk about, just quickly, the guides concerning the use of endorsements and testimonials, these are designed to assist businesses in conforming their endorsement practices to the requirements of Section 5 of the Federal Trade Commission Act, which generally prohibits unfair and deceptive acts and practices in advertising. These guides, which were enacted back in 1980 and amended in 2009, interpret the laws that the Commission administers. And while they're advisory in nature, the FTC can take action under the FTC Act, if an endorsement does not comply with the guides. In that situation, the FTC has to prove that the challenged act or practice is unfair or deceptive in violation of Section 5. The guides define both endorsements and testimonials very broadly to mean any advertising message that consumers are likely to believe reflects the opinions, beliefs, findings, or experience of a party other than the advertiser. And with respect to customer reviews, the FTC takes the position that those, by essentially definition, would not be obvious to a consumer that they are either incentivized or compensated or do not reflect an actual user of the product or service. As I mentioned, the guides were most recently amended in 2009, which was a really important update given the use of the internet to advertise. And so those amendments brought guides into the 21st century. Just last month, which now feels like a lifetime ago, the FTC issued a notice seeking public comment on whether or not it should make further changes to its endorsement guidelines. This is part of the FTC's regular review of all of its rules and guides. And it specifically is seeking comment on a few areas that relate to customer reviews, including whether or not incentives actually bias reviews, even when a favorable review is not required in order for the reviewer to receive the incentive, and whether or how those incentives should be disclosed. Another area where the FTC is seeking comment is whether composite ratings that include reviews based on incentives are misleading when reviewers, even if the reviewers are disclosing that they were incentivized in the underlying reviews. And what, if any, disclosure advertisers or operators of review sites need to make about the collection and processing of publication of reviews. The current deadline to submit comments is April 21st, 2020. Given the coronavirus pandemic, I expect that that deadline will be pushed out. If anyone here uses either customer reviews or social media influencers or endorsements and testimonials generally, I highly recommend taking a look at this public comment request because it covers a lot of ground. So who enforces both the Federal Trade Commission Act and its guides and other statutes that would regulate consumer reviews? The FTC and state attorneys general have jurisdiction over anyone who participates, either in the creation or dissemination of this advertising, or anyone who directly or indirectly participates in presenting the advertising content. And this covers any entity or person that is involved. So the advertiser, any third-party agency or SEO company that is involved, affiliate marketers, publishers where the reviews are being published, and the actual endorsers themselves. We'll talk a lot about FTC and the cases it's brought under this, but the New York Attorney General also has been very active in this area. In 2013, for example, it conducted a 1-year-long investigation that resulted in a sweep against just about under 20 companies that either created or bought reviews, alleging that that was false advertising, including a company, an SEO, search engine optimization company, that promised to help merchants combat negative reviews through SEO strategies and by adding fake positive reviews. In addition to the FTC and state attorneys general, there's also a lot of self-policing and self-regulation in this space. Competitors continue to bring cases against each other before the National Advertising Division, NAD. We'll talk about some of those cases. And then you're seeing the review platforms like Yelp and Trustpilot also taking increased action against companies using algorithms, et cetera, to identify fake reviews. And we'll talk about some strategies that companies have undertaken to try to avoid those detections and how it's landed them in trouble. So as I mentioned, reviews are considered endorsements. And so what are the basic rules that govern endorsements and testimonials as issued in the guide? So first, endorsements must reflect honest opinions, beliefs, or experience of an actual user of the product or service being endorsed. And so that's why we talk about fake reviews. Those are inherently false and considered false advertising. Second, endorsements cannot contain false or misleading statements or implications. And so we'll talk about how an advertiser or review platform would be able to know if there are false or misleading statements in the reviews, but to the extent there is knowledge or encouragement, that would be considered deceptive. Third, the advertised portion of the endorsement must reflect complete testimonial. You can't just pick and choose excerpts from the endorsement to give an inaccurate portrayal of what the consumer actually said. Cannot use testimonials or endorsements to make claims that you as the advertiser cannot make directly. So we'll talk a little bit about what that really means when in practice, but essentially, basic laws of advertising still apply here. So to the extent that a endorsement does convey a claim about results or performance, it has to either be reflective of a typical result of a user of the product or service, or requires a disclosure of what the typical results are. To the extent an expert is making a review, submitting a review, and is portraying him or herself as such an expert, they must possess the relevant expertise that is relevant to the credibility of the endorsement. And then finally, which we'll talk about in some detail, is any material connections that might affect the credibility of the endorsement or the customer review must be disclosed. And so the FTC has brought a handful of cases over the years against advertisers and their third-party agencies who posed as consumers and reviewed the product without disclosing the connection between him or her and the seller of the product. The bottom line is posing as a consumer to post a review violates just basic advertising law. There was a couple of cases brought in the mid-2010s against companies that were advertising their video game consoles, and during those kind of video game console wars, heavily using influencers to kind of unbox and provide real-time feedback while playing the video games. And the failure to disclose the fact that they received either compensation or free games and consoles, and therefore when they were endorsing the games while they were playing on these YouTube channels, the FTC concluded was unfair and deceptive under the guides and therefore the Federal Trade Commission Act. More recently, the FTC brought a case against a cosmetics company, which I mentioned earlier, that that was selling on Sephora's marketplace and was requesting and actually ordering employees to create profiles and submit fake reviews in order to push the products higher in the rankings, which impact how they're displayed on the website. And so the FTC found that there was a lot of deliberate conduct there, supervisors directing employees to create profiles in a way that would evade Sephora's technology, which was able to identify whether reviews were being submitted from the same ISP address, et cetera. So the FTC really, and I quoted from Commissioner Chopra's dissent in that case, the FTC in that matter has really laid down a marker in terms of the importance of rankings and understanding that the way that products on third-party sites like Amazon, Sephora, etc., get ranked is very much reliant on these reviews, which in turn incentivizes advertisers to try to quote-unquote game the system. So the FTC is looking at advertisers and these third-party companies that assist with these types of strategies very carefully. And so the bottom line is, with respect to your customers or incentivizing customers to submit reviews, it needs to be disclosed, whether it's in the actual review by the customer or on the website it's being displayed. So to the extent that you're collecting reviews to put on your own website, you have the ability to disclose exactly what, if any, incentives customers were offered in order to submit the review. This is required regardless of whether the incentive is based on whether the customer submits a positive review. Even if it's neutral and just says, you know, please submit a review and you'll get 10% off your next purchase, and the review is negative and it's posted, that still needs to be disclosed. And I advise basically clients, if it's gray at all, then there should be a disclosure. Unless and until the FTC clarifies exactly what it expects to see in these customer review displays, there's really no way to ensure compliance without a disclosure. And in some ways, the fact that the FTC is considering amending or updating its guide, I think is a good thing. I think the last 11 years, since it was last updated, there's been tremendous changes in social media platforms and how customer feedback and user experience is being incorporated in advertising, and therefore some additional clarity from the FTC could be welcomed. As I mentioned earlier, the NAD, which is a self-regulatory body where advertisers can challenge each other's advertising, or the NAD can, based on its own monitoring of advertising, can bring a challenge, has considered a lot of these issues as well. A lot of these NAD cases provide a lot more practical application on how to comply, whereas the FTC enforcement actions and the press releases and blog posts the FTC puts out are pretty vague. I think the NAD decisions, and we'll talk about a few of them here, provide a lot more specific guidance to advertisers on how to comply. So the NAD, just like the FTC, has said that product reviews are endorsements, which invoke the requirement that material connections between the seller/advertiser and the endorser has to be disclosed. And as we said, incentivized reviews would always require disclosure if not reasonably anticipated by the consumer. The NAD also has made clear that a claim that an advertiser cannot make itself cannot be made through consumer reviews. So as with any claim, it needs to be substantiated. In a 2019 case, the NAD had directed an advertiser to remove claims that the product it was selling was made in the United States. And the advertiser had done that, but customer reviews were still coming in and being posted that talked about the fact that, or talked about the fact that the product was made in the United States. And so a competitor challenged the fact that the company was continuing to post these customer reviews that talked about the product being made in the United States when in fact it had not been, and said basically that the advertiser was still benefiting from that false claim by it appearing, on these customer reviews that were completely genuine and submitted by actual customers. The NID concluded here that the advertiser here, APIC, did not exercise sufficient control over the message's truthfulness, and really emphasized the fact that because APEC did not respond to the specific reviews that included these made in USA claims, did not interact with the consumer submitting the review, that it in turn did not have sufficient control over the message, and therefore it was not considered to be deceptive to continue to display these reviews that included these claims which were not accurate. And so while the FTC has not really weighed in on this specific issue, meaning if a review that was, genuine review submitted by a customer includes information that is not accurate, what is the responsibility of the advertiser? The NAD has seemed to put a line where, in terms of control and knowledge, based on whether or not the advertiser had been somehow involved or participated by responding, or of course incentivizing the specific claim to be included in the review. Other NAD cases confirm what the FTC has already stated with respect to customer reviews. So soliciting reviews by encouraging users to write positive reviews in exchange for free products is considered deceptive if that is not disclosed. The NAD has recommended that the disclosure can be made even retroactively to the extent that they're not going to be taken down. And similarly, also suggested that at a minimum, advertisers should not incentivize only for positive reviews to be submitted, but should be neutral about offering the incentive. So closing up on the endorsement guides and how they apply to customer reviews, just a few best practices. So to the extent that you as an advertiser are soliciting customer reviews, and a lot of advertisers do this in a variety of means. For example, I'm sure all of you get these emails after buying a product online asking you to submit a review of the product or experience. Other websites of sellers allow customers to submit directly to the website reviews, and that's of course how third-party review sites and third-party platforms like Amazon operate. Give clear directions to reviewers to disclose any connections or incentives that are offered to submit a review. That's a basic step you can take to ensure that you are at least meeting your obligation to inform third parties of their requirements. Require disclosures, or even better, automatically tag incentivized reviews on social media sites. It's easy to do these days, and ensures that you don't have to rely on third parties for compliance. Monitor and enforce disclosure requirements, and before using reviews as a basis for a claim or a survey or some sort of aggregate composite rating, independently substantiate any claims that are contained in customer reviews. Don't use reviews or social media reposts as a backdoor to make claims that you otherwise could not make directly. Carefully evaluate cross-platform compatibility before aggregating reviews. And don't forget about offline purchasers. And so here, when we talk about, aggregate reviews where you're using all the submissions to create a star rating or any other type of composite review, the suggestion or the implication of that is that all reviews have been fairly incorporated to give that aggregate composite rating. And so to the extent that you are cherry picking reviews to include in that composite rating, that's going to be a problem because it's a distorted actual rating, right? And so when you think about either if you're using a third party to collect reviews or are soliciting and collecting reviews through a variety of platforms, online, offline, email, website, etc., you want to make sure that you are looking across all of these various platforms when creating a composite rating, unless you're providing adequate disclosures about what's not included. And so you need to take a step back and look at the net impression of both how reviews are displayed on the website, but also how the composite rating is displayed. So don't cherry pick product reviews when displaying them, and be very forthcoming with your process for selecting what is posted, what is not posted. And this is a good segue to our next topic, which is managing negative reviews. Obviously, the internet is a place for anyone and everyone to express themselves. It is the democratization of opinion, and it includes a lot of negative and inaccurate, oftentimes, reviews. Trolling online, of course, is a big problem for companies, and increasingly they are looking for strategies and assistance to combat the trolling. The pendulum swung so far the other way that Congress, in fact, decided to intervene, and a few years ago passed a statute called the Consumer Review Fairness Act. So I'm going to pass the baton to Deborah to talk about the statute, what it does, what it does not do, and then we'll talk a little bit towards the end about managing negative reviews in a compliant fashion more broadly.
Thanks, Alex. So the Consumer Review Fairness Act was enacted in December 2016 and became effective in March 2017. And it gives enforcement authority to the FTC and the state's attorneys general. And violations of the CRFA are treated the same as a violation of the FTC rule that defines an unfair or deceptive act or practice. So a company could be subject to financial penalties, and they could also be subject to a federal court order. So overall, the purpose of the CRFA is to protect consumers' ability to share their honest reviews of products and services and promote transparency and free speech. If Alex doesn't have anything to add, I'll move on to the next slide. Great. So what does the CRFA actually do? Big picture, it makes gag clauses illegal and void in form contracts. And the CRFA defines a form contract as a contract with standardized terms used by a person in the course of selling or leasing the person's goods or services and imposed on an individual without a meaningful opportunity for such individual to negotiate the standardized terms. So an example of that would be a website's terms and agreements. And the CRFA does not apply to employer contracts or independent contractor contracts. So the CRFA makes it illegal for companies to use a contract provision that bars or restricts the ability of a person to review a company's products, services, or conduct, imposes a penalty or fee against someone who gives a review, or requires people to give up their intellectual property rights in the content of their reviews. And the use of a non-disparagement clause, even without the threat of a penalty, is enough to violate the CRFA. And the CRFA establishes that just the existence of an illegal contract provision is enough to subject the company to an enforcement action, even if the company did not follow through against consumers. So basically, it prohibits a business from using form contract provisions that bar consumers from writing or posting negative reviews online or threatening legal action or fees if they do. And companies can also be subject to financial penalties for knowing violations of the CRFA. I'll move on to the next slide. Great. So what does the CRFA apply to? It applies to a variety of consumer assessments. I think Alex mentioned a bunch of them before, including online reviews, social media posts, uploaded videos, and uploaded photos. And again, it does not just cover product reviews. It also applies to consumer evaluations of a company's customer service. So that doesn't mean all reviews must stay up online. So what types of reviews are not covered by the CRFA? Reviews that contain confidential or private information, reviews that are libelous, harassing, abusive, obscene, vulgar, sexually explicit, or inappropriate with regard to race, gender, sexuality, ethnicity, or other intrinsic characteristics, any reviews that are unrelated to a company's product or services, and reviews that are clearly false or misleading. And a disagreement over a consumer's assessment or opinion likely won't meet the clearly false or misleading standard mentioned here.
So I'll just jump in here really quickly just to make clear. So the statute expressly carves out these types of reviews or reviews that contain this type of content. And so what that means is a form contract that prohibits your customers from posting reviews or posts that contain this type of information are permissible under the statute. So those can still exist so long as they're very, carefully drafted and otherwise in accordance with the statute.
So what is the FTC doing? How are they enforcing the CRFA? In May 2019, the FTC issued 3 proposed administrative complaints and orders enforcing the CRFA and against companies from different industries. All of these complaints and orders were approved in August 2019. And then in June 2019, the FTC announced 2 additional administrative complaints regarding companies that violated the CRFA, again, by using form contracts with non-disparagement provisions that barred consumers from writing or posting negative reviews online or imposed financial penalties for doing so. And these final orders were also approved in August 2019. So on the next slide, there's just an example of some language that the 3 May 2019 enforcement actions used in their contracts. And again, they were confidentiality clauses or non-disparagement clauses. So this is just a brief example of that. And then June 2019, again, an example of some language. And the June 2019 enforcement actions, they addressed companies with contracts that had non-disparagement clauses. And one company, Sure to Please, actually filed a lawsuit against a renter who posted negative reviews online and stated that the renter owed them $25,000. Move on. So what did the consent orders with the FTC require the companies to do? All of the orders bar the companies from using non-disparagement clauses in their form contracts and also requires them to notify customers who sign those contracts that the clauses are not enforceable and that the customers can actually post their honest reviews online. And in the order against Sure to Please, who actually sued a renter, It required the company to dismiss with prejudice a count in their private lawsuit, which the company alleged a renter violated the non-disparagement agreement. And so the companies cannot offer a form contract that includes a review limiting term or requires that a customer accept such terms as a condition to the contract. Alex has nothing. I'll go the best practices. Okay, great. So how to comply with the CRFA. One should review their existing form contracts to make sure they do not contain the types of provisions discussed earlier. If the form contracts do have illegal provisions, notify customers of the invalidity of these provisions. Do not include gag provisions in any new form contracts. Again, as Alex mentioned, don't cherry pick which reviews to post online and which not to. And to remember that the FTC Act also applies, and any questionable conduct can also be challenged under Section 5 of the FTC Act.
So a few more things I wanted to add with respect to the CRFA. Obviously, having a compliance policy that deals with updating your terms and services online and any other consumer-facing contracts is really important. If you have not, since the passage of this statute, taken a look at your online terms and conditions or terms of service, which typically bind any consumer that's purchasing from you, whether online or in the store, then you really should, because the FTC is increasingly taking a look at companies' terms and conditions or terms of use on their website to see if there are these types of non-disparagement or gag clauses. And even if customers are not reviewing them, obviously from an advertiser's perspective, they are binding, and even if they're not enforcing them, they could be a problem. Also, just non-disparagement agreements with customers need to be very carefully drafted. We've noticed in several recent lawsuits brought by the FTC that have alleged a host of violations of the FTC Act. They're throwing in additional counts or claims under the CRFA, looking at consumer-facing agreements that really were not intended to to prevent customers from, submitting reviews, but were intended to serve as really a non-disparagement clause to try, which should under the CRFA be permissible still, but the drafting of it was not tight enough, and the FTC has taken the position in those lawsuits that the clauses in the agreements broadly would have inhibited a reasonable consumer from expressing his or her opinion about their service. And so oftentimes the FTC will throw in more specific statutory violations when making kind of broader deceptive claims, because it's usually easier to prove in a more specific case here, the CRFA. So while certainly this FTC is not, bringing big time cases under this statute, it is oftentimes throwing it into cases as an extra claim or count. We received a few questions about disclosure of incentivized reviews and what are some good ways to do that. So to the extent that we're talking about posting reviews on your own website where you have the ability to control the information on there, what I generally recommend is that customer reviews that are either on a dedicated web page or that are incorporated and displayed along with the specific product. Like if it's on a product page, that along the top you have either a link to your review policy that would lay out specifically how reviews are solicited, reviewed before being posted, and what kind of reviews get taken down to the extent that customers can just submit reviews without it going through a filtering process first. To the extent that we're talking about incentives, so if customers are offered a discount for a future purchase or free product, that should appear across the top clearly and conspicuously, not through a hyperlink, because that clearly is going to be something that would affect the credibility of the review. On third-party sites, it's obviously very difficult because you don't control what's displayed there, but at a minimum, you'd want to tell your customers in the prompt that they should be disclosing the fact that they received incentive or payment. And then to the extent you're reposting, and that's where we talked about earlier with the APEC and AD case, where you're exercising some level of participation or control or knowledge by reposting or interacting with that customer review on a social media platform, for example, that could be a problem. So if you are reposting or saying thank you for the review, interacting with the customer that there was an incentive there, there's an opportunity to add the disclosure. And that's where I would recommend you do so. Another question we received relates to how do you not cherry pick reviews when you're creating an advertisement that you're only kind of focusing on positive reviews. That's a little bit different because there we're talking more about a testimonial that is, the net impression of that advertisement is not that you are displaying or representing that all of your customer reviews are positive. So when you think about, whether or not the net impression is suggesting that all the reviews or most of the reviews are being displayed or incorporated just like a aggregate rating implies, then you need to be careful about cherry picking. But if you're focusing on just a couple, one or two positive reviews in an advertisement, I think it's fair to say that that does not imply that all of your reviews are positive. And so a lot of this, of course, is not perfect and it's not a science. And, each of these ads need to be carefully reviewed by either counsel or compliance professional. But there is some level of common sense that you can apply in terms of deciding whether or not something is being depicted as reflective of your full customer base, as opposed to really focusing on a few testimonials that suggest a positive experience with the company. Another question we're receiving is, are there any prohibitions or restrictions on revising reviews? Don't recommend editing reviews that are submitted by customers. You would certainly have to disclose the fact that it is curated and essentially more of a piece of advertising than an organic review that accurately depicts what the consumer's opinion was. And so that said, to the extent we're talking about moderating because there's, an inappropriate word in the review, et cetera, and you're able to redact it, that probably is fine, but otherwise manipulating the review is going to have to be disclosed. And as Deborah mentioned in her description of what the Consumer Review Fairness Act excludes, you'll recall that illegal content or libelous content, harassment, there's a whole host of categories on what I always put in this inappropriate content bucket. I mean, I use that as a guideline for not necessarily, what types of reviews are, you can prohibit your customers from posting in a form contract, but also in terms of what would be appropriate moderation on your own website. So look at those buckets that the FTC has put into its statute as, guidelines as to the types of content you would not, be able to exclude because it's either illegal or inappropriate in some way. And so I typically look to those as safe reasons for not including a review. And then finally, question about whether or not claims that are included in a review would be a proper reason to take down a review. I think one of the reasons I'm somewhat excited and happy that the FTC is considering a review of its guidelines with respect to endorsements, testimonials, and including review practices in that possible update is because there's a lot of uncertainty around what content can be moderated and what content cannot be moderated in order to present an accurate picture of customer or product reviews on websites. And these are questions that both advertisers on their own websites have, but also the third-party review sites like Yelp have. And companies like Yelp have pretty extensive policies that are on the website that explain how they conduct themselves, what types of content they're moderating for, et cetera. And I encourage advertisers on their own website, to the extent that they're accepting and posting reviews, to take a look at those third-party sites and also put on their own website, disclose exactly how you're soliciting reviews and moderating them, because the FTC, it's one thing to say it's not appropriate to put up fake reviews. I think that, it's very black and white, but in terms of deciding whether some reviews should or should not be posted because they contain, inappropriate content or inaccurate content is a much harder question. And so I generally would say is come up with a set of guidelines, and I would try to model them based on the Consumer Review Fairness Act exemptions that the FTC has already considered, and then post those guidelines and then comply with them. You don't want a situation where your guidelines say that, all reviews will be posted unless they contain, sexually explicit language, and then you're only taking down negative reviews that contain that type of language, right? So the key is to create a set of guidelines and then comply with them consistently so that there's no manipulation based on something being positive or negative, and therefore distorting the customer's expression of their experience with your product, service, or company. And I think there will be many more cases coming out by both the FTC and NAD that will be providing additional clarity on these types of issues. I get the sense that the FTC is only starting to wrap its head around how customer reviews are being collected, how they're being used, and how there's third-party or companies out there that are essentially a cottage industry to help companies manage the volume and viral nature of very harsh negative reviews. And so I think you'll see the way the FTC has been relatively proactive on influencers and hashtag ad and the requirement to disclose that connection. I think you'll see the FTC pushing out more business-friendly, practical advice on customer reviews, even before they get to deciding whether or not to amend the guides, which could take up to 2 years given the process by which those guidelines need to be amended and public notice and comment have to be incorporated. So with that, we've run out of time. I thank you all for taking this hour, not watching the news, and joining us to talk about customer reviews. If you have any questions that we did not answer in this hour, please email me or Deborah. You have our email addresses. We will be happy to get back to you. And again, we thank you and stay safe.